Thank you for joining us this afternoon. We're going to wait just a few more seconds to allow people to finish entering, and then we will begin. Good afternoon. Welcome to our sixth Lunch and Learn presented by the Charlottesville Police Foundation and the Charlottesville Police Department. My name is Gail Milligan. I'm the Executive Director of the Foundation. Now is such an important time for us as members of the community to understand more about policing and the law, and that makes us excited to be presenting this series and very happy that you're joining us today. We so greatly appreciate the partnership with CPD and the time and effort all of the presenters have invested in bringing this information to us. We also appreciate the support from the Batten School of Leadership and Public Policy and from our hosts, Diane and Katie. The Lunch and Learn series is one of the outcomes of our engagement in the community last year and is part of our core mission to inform and connect. In each session, our presenters will offer unique insight to their work and answer questions you have about that work. Before we begin, I want to share a brief overview of our work at CPF. Simply stated, the Charlottesville Police Foundation serves the community by serving the police. We seek to improve the quality of life in Charlottesville by offering a community partner for our police department. The foundation promotes excellence in police services by investing in programs that enhance the department and yet are beyond the reasonable reach of the city's budget. We reward excellence. We strengthen the connections between the department and the public through outreach programs and community events. Some of the ways we serve include housing grants to officers so they can live locally, an awards dinner and Officer of the Month program, advanced training, grants for specific needs such as K-9, technology and new community programs, outreach events like Cops for Kids Day, and the Charlottesville Night Out, which celebrates police and community. To clarify a common misperception, we are an independent 501c3 nonprofit, and while we partner with the Charlottesville Police Department, we don't report to the CPD or to the City Council. We are not a police union and don't do the work commonly associated with police unions. To the extent that we advocate for the CPD, it is to improve the quality of policing as a community service. Now I'd like to introduce our presenter. Joe Platania, Commonwealth's Attorney of Charlottesville, has sat on both sides of the courtroom. He first served in the Charlottesville Albemarle Public Defender's Office in 1999. And almost 20 years later, he was elected to his current role of Commonwealth's Attorney. Throughout his career, he has sought to improve criminal justice in Virginia. A quick note before we begin, you can add your questions to the Q&A section on the bottom of your screen, but we'll hold your questions until the end of the presentation. Joe, thank you so much for being here.
Well, I would like to thank you, Gail, Diane, the Charlottesville Police Foundation, and the Charlottesville Police Department for having me. Gail briefly introduced me, but I'll go into just a little more detail because I think my background sort of informs my philosophy as a prosecutor. I graduated from law school in 1998 and took a job in Richmond, Virginia at the Virginia Resource Center defending death row inmates. And it was appellate post-conviction work. So I was doing legal research and writing and pretty quickly realized that wasn't sort of my strong suit. I would rather have been in a courtroom talking to people and interacting with folks. And so in 1999, Jim Hingley was opening the Charlottesville Albemarle Public Defender's Office. it had been funded by the General Assembly, and I applied and was fortunate enough to be one of the 7 original attorneys in the Charlottesville Albemarle Public Defender Office. And so came to Charlottesville in 1999, was a public defender for almost 5 years, really enjoyed the work, loved my colleagues, but I saw that the prosecutors had an awful lot of power in the system and had an awful lot of influence about how my clients would be treated. And there were several city prosecutors who, to me, were just incredibly skilled and talented and fair. Dave Chapman, Claude Worrell, Rick Moore, Ron Huber, John Zug. And they had a vacancy in 2003. And I never wanted to be a prosecutor, but I, again, saw the power that they had in their role in exercising their discretion about the impact they could have on people's lives, both victims and offenders. And so joined the Charlottesville Commonwealth Attorney's Office in 2003, working for Dave Chapman. He retired in 2017, and I ran for office and was elected and started as the Charlottesville Commonwealth's Attorney January 1st, 2018. So what I have a little sign in my office, and everyone that works with me is sick of hearing it, but the sign says "Culture Eats Strategy for Breakfast," and it's from a business book. But what that means to me, and what I tell my colleagues and teammates here, that culture eats strategy for breakfast, what that means is if you create the right culture and people understand what that culture is, and it's simple, it exists over time, it applies to every situation, and the culture will get you to the right place in almost every instance. And the culture that we promote here is community safety balanced with the fair treatment of offenders. As a prosecutor, you certainly want to treat offenders fairly. The impact that a criminal prosecution can have on the life of an offender and their family members and loved ones is significant. And we as prosecutors understand that in this office. Of the 6 lawyers here, 4 of us were public defenders prior to prosecuting, and the other 2 we grabbed while they were law students and trained them and hired them upon graduation. So while there's a national conversation on criminal justice reform, it's something that has been going on for a long time in this office, going back to Dave Chapman. And the fair treatment of offenders is very important to us, and it's very important to me. But that has to be balanced with community safety and keeping the community safe. And that's the other part of our job that is very important. And I'm going to share 2 anecdotes with you and then open it up for questions that I think demonstrates how we bring that culture to bear in actual cases. So the first case I want to talk about is an example to me of the fair treatment of an offender. An older gentleman was out in his neighborhood. He was pretty intoxicated. He was in his maybe mid 40s, so he wasn't real young, meaning 18, 19, 20. He was sort of older, and most people age out of some of this criminal conduct. And he had a gun and was drinking, and a neighbor called and a patrol officer responded and interacted with the gentleman, and he was cooperative. He was intoxicated, but the officer's like, I'm getting a report of a firearm, and he asked the gentleman some questions, and the gentleman said, yes, I had a gun and it's right over there on the wall and I'm intoxicated. And the officer ran his criminal history. And what he discovered is that the gentleman had like a 20-year-old breaking and entering felony conviction. And in Virginia, unless your rights have been restored, you're prohibited from possessing a firearm if you're a felon. And breaking and entering, to many people's surprise, is considered a violent felony. And so when your prior felony is violent, like a breaking and entering, it's a 5-year mandatory minimum prison sentence. Judge can't do anything about it. And so the officer appropriately arrested the individual, charged him with felon in possession of a firearm, with the prior felony being a violent felony, because it was, and the gentleman went to jail. So that case came to me within a couple days, and what I had was a slam dunk case. I mean, there was literally no defense to this case. The gentleman had a prior felony. We had a copy of it. He possessed the gun. He confessed to possessing the gun. We had the gun. It was open and shut. and he was going to go to prison for 5 years. And there wasn't anything a defense attorney could do about it, and there wasn't anything a judge could do about it. But again, prosecutors are able to exercise discretion in certain cases. So I get a phone call from the public defender representing him, and she said, look, I know things don't look good, but the first thing I want to tell you is my client made a poor decision, but he's got a stable residence, he's got a job, and he does sort of outreach work with kids in the community. And in his basement sort of helps make music with them. She said, so I think we've got a good release plan. Can we get him out on bond? And I called the patrol officer and said, is there anything I need to know about this? And he said, no, he's very cooperative. And, he's not known to us to be involved in sort of violence or anything like that. And so as a prosecutor, this is the first sort of decision point that I was able to go in front of a judge and say, Judge, we're asking that he be released back into the community. And here's the plan that they put together. And here's why we think it's a good idea. And the judge places a lot of weight in what the prosecutor says, because we're, again, charged with community safety. And he said, all right, if the prosecutor's agreeing and the defense attorney's got this plan put together, I'm going to let him out. And, there's this national discussion about all these people in jail because they can't post their secure bond and cash bail. We have not used cash bail in Charlottesville in over 10 years. You either need to be in jail because you're a danger to yourself or the community, or you should be out with a good release plan. So he was able to be released without having to put up any money. And we were set for a hearing date. So the next phone call from the public defender was, I don't think that this gentleman needs a 5-year prison sentence. She said, he committed a crime, he's guilty, you can prove it, but I'm not sure he needs to go to prison for 5 years. What do you think? And I agreed. And so as a prosecutor, I was able to amend the charge and literally take a pen and cross out violent felony and just say felon in possession of a gun. The judge granted the motion to amend, and the mandatory minimum disappeared just by that amendment by the prosecutor. So now the gentleman was looking at 0 days in jail up to 5 years, but no mandatory minimum. So all of a sudden, as a prosecutor, I leveled the playing field and said to the defense attorney, we can each make our arguments and let a judge decide. And I trust our judges, and they'll get it right. And I'm not going to tie the judge's hand, and I'm not going to tie your hands that you can't advocate for this gentleman. She said, wow, that sounds great. And this is not a story patting myself on the back. This is a story of how really any prosecutor should go about balancing community safety with the fair treatment of offenders. And it's my expectation that anyone that works in this office, this is exactly what they do. So we come up to the guilty plea, and I'd been thinking, and I said, look, and by the time we got to the guilty plea, 6 or 9 months had passed. The gentleman had been out, he'd been doing well, he'd stayed out of trouble. He was working, he had a stable residence, just no problems whatsoever. And I said to the defense attorney, when we were getting ready for the guilty plea, I said, look, he's got 6 to 9 months of a track record of doing really well. I don't think I even need a felony conviction here to keep the community safe. And I certainly think to treat him fairly, maybe we can think creatively. And so what we told the judge, we entered into a plea agreement. And only a prosecutor can enter into a plea agreement. You can't be forced to. And we said, we're going to let him plead guilty to the felony, but we're going to ask the court to not convict him or find him guilty. And let's bring him back in a year and see how he does. And if he does well for a year, we can reduce the charge to a misdemeanor reckless discharge of a firearm. And if he doesn't do well and he makes a mistake or commits a new crime, then the felony conviction enters and we would go to sentencing. So it's very low risk for me as a prosecutor. He was seeing a probation officer, he was being monitored. So we had a way to sort of check all of this. And so we did that, and the judge was happy to grant our motion to take it under advisement for a year. So the gentleman comes back a year later. He's now approaching 2 years being out and about in the community. No trouble, no new charges, stable residence, employment. And I did feel that there needed to be some documentation of his conduct with a firearm. But I was fine with a misdemeanor reckless handling of a firearm. And so when we came back a year later, he had a great progress report. He was happy. He was doing well. He knew he had made a mistake, but he ended up being convicted of a misdemeanor and being given a suspended jail sentence. So that story I tell all the time. because it's an example of how a prosecutor can have great power and discretion to make sure that an offender is being treated fairly. So I said at the beginning that along with fair treatment of offenders, we're also charged with keeping the community safe. The other anecdote I'd like to pass along is I get another file on my desk and called the detective that had worked it. And there was a gentleman, I'm just going to call him John, whose name kept coming up as being involved in shootings in the city. And a lot of times as prosecutors, you get information from law enforcement, but there's not admissible evidence or there's not enough to charge. But, it's just like this guy's name keeps coming up. And so they were doing some surveillance on him as a person of interest in some of the gun violence. And their surveillance one night, they located him and they visually saw him holding an assault rifle by a vehicle. And he was also a convicted felon. And they saw him get in the car and they radioed, look, we saw him, he's got an assault rifle, he's a convicted felon, and he's getting in the car and driving off. And so they got a marked patrol vehicle to start a pursuit. And they put on lights and sirens, they had their dash cam activated. And, he started going 70 or 80 miles in the city of Charlottesville and was not pulling over because he had an assault rifle and he was a felon. So they pursued him for a couple minutes, and then the pursuit was called off by a supervisor because it was putting other people on the road at risk. And he got away. And about a week later, they saw him again, and they had warrants for felon in possession of a gun and felony looting, and they initiated a second pursuit, and they caught him the second time. After, again, a long chase, he finally sort of crashed somewhere, and they were able to apprehend him. So he had 2 felony counts of eluding, 1 count of felon in possession of a firearm. He had a prior drug felony conviction. But that was a case that I sort of knew what I was going to do with it, but I talked to the detective and I said, this guy's out there. He's got an assault rifle. His name's coming up in shootings. He's not pulling over for police. He's putting officers and citizens at risk. This is going to be prosecuted, and he needs to be sentenced to an amount of time that will, keep him out of circulation for a while and keep the community safe. And the detective, of course, agreed. And, that case just gets prosecuted. All 3 felonies get prosecuted. Now, I don't think he needs, 8 or 10 years in prison, but he needs a significant time out in order to keep this community safe. So there's 2 very different cases and 2 very different ways that, the philosophy of balancing community safety with the fair treatment of offenders plays itself out. And culture eating strategy for breakfast is, what's the culture? And, when we make decisions, the first guy clearly had a path to something less than 5 years. And the second guy, to me, clearly had a path where he needed to be prosecuted for the felonious conduct that put a lot of different people at risk, and it was involving a gun. So those are 2 stories that I think illustrate the point that I tried to make at the beginning. And it's about 20 after 12, and I know there's a lot of questions that you might want to ask. I can fill up more time, but I think it's more useful to hear from you and what you all would like to talk about.
Great. Joe, thank you. So there are some questions, and I'm just going to see. Can you speak some to the unmet mental health needs of community members and how it impacts your ability to both treat people charged with crimes fairly and maintain public safety?
Sure. Hi, Anna. How are you? I'm assuming this is the Anna Mendez I know, and she's a wonderful advocate. Again, the balancing the public safety with the fair treatment of offenders. So I think the first thing, and Anna, I know you aren't on speaking about this, but you could probably speak very intelligently and expertly about this through your advocacy work in a way that I might not be able to. But it seems to me as if there's a growing awareness societally that folks that may have certain mental health issues, we really need to figure out how to divert them out of the criminal justice system and into treatment and services. even while we might recognize that they might be out doing something criminal or illegal. And you see it play out a lot, and there's a tension between, officers interacting with someone that might be armed, but they've got mental health needs. So part of your question deals with the first responders and the police officers and how they approach interacting with folks. We have a CIT program, a crisis intervention team model and program, where you get officers that are hopefully specifically trained in dealing with individuals that might be suffering from mental health issues in a way to sort of get them diverted and not arrested, and get them, either involuntarily committed if they need that. But so that's one point where the officers can deal with it on the front end and try and avoid an arrest. The other is, we, as Anna knows, we've got a therapeutic docket for misdemeanors. I think we'd love to see that expanded to felonies and into juvenile and domestic relations court. But just because someone is charged with a crime doesn't mean that the prosecutor can't do what I mentioned in that first instance and figure out a way to get them out with a good, stable release plan, get them services, get them treatment, get them linked up with professionals like Anna and Mental Health America, and have the charge ultimately taken under advisement and dismissed if they can stabilize. And so I think, again, there's not a great answer, but I think if you go into it trying to figure out how to get these folks stabilized and get them into treatment and services versus prosecuting them, that's a win for the offender, of course, but it's also a win for the community, because if we can get them linked up into these services and treatment, then we don't need to have them, back and forth in the system. We see it come a lot in assault law enforcement cases, and this is tricky. I had a case where a gentleman was off his meds and was mentally ill, and the officer responded, and he had shattered the window of a business on the downtown mall, and the officer was trying to get him under control. I think he was also under the influence of drugs and alcohol, and he punched the officer in the face, and he split his lip open. I think he needed stitches, but clearly suffering from mental health problems. He ended up going to Western State for some restoration services, and they got him stabilized. They got him on some appropriate psychotropic meds. And the officer was very supportive of getting that reduced down and not prosecuting him for felony assault law enforcement, which he was technically guilty of. But he was someone that we kept out for about 2 years and monitored. And he really, when he got the treatment and services he needed, he really turned himself around. And again, it's a credit to the officer who was punched and had his lip split open and said, no, I want this person to not have to pay. And the officer was the victim of the crime, to not have to pay with mandatory jail sentences on felony assault law enforcement. If he's doing this well, and the individual also wrote a really touching personal letter of apology to the officer, which the officer, I think, really appreciated. The defense attorney facilitated that. So that's kind of a long, drawn out answer, Anna, but I don't think there's a simple way to do it. You just got to be mindful for what are you trying to accomplish.
Thank you. We have, because wanted to make sure if somebody wanted to say something, allowed people to have a response. So Anna, if there's something if you have a question, or if you want to respond to Joe in any way, please feel free. We would encourage you to do that.
Thank you. Thank you so much, Gail. I was not anticipating this. Hi, Joe. Thank you. Thank you so much for your thoughtful response to my question. We hear a lot of feedback about people being frustrated with the criminal justice system and how it generally doesn't serve people living with serious mental illness very well. And while that's true, I also am a strong advocate for a root cause analysis. And as long as there are unmet mental health service needs in our community, then you and your office and Chief Brackney and her police officers are going to continue to be put in really impossible situations. Absolutely, we need to, hold everyone in power accountable when things don't, go well. And I think we have a system in Charlottesville that does that better than most jurisdictions in Virginia. And if we aren't having a conversation about the root cause of these challenges are just going to continue to exist. And so I would love to see more robust community conversation about the need for increased funding coming from the state level for mental health services. I don't believe that this is a problem. Yes, we could do things better locally, but I really believe that this is a state level problem. And so I guess really the point of my question is just in some ways to illustrate that until we have systemic change, we're going to continue to see these challenges over and over.
Yeah, thanks for that, Anna. I think it also applies to our school system. I think it applies to affordable housing. And so, I say to I teach 30-year law students, and I say, if you want to be a prosecutor, remember, just because you have a hammer, everything is not a nail. But in many ways, the criminal justice system is a blunt instrument, and we need a more finely honed instrument to deal with some of these problems. But well said, and I think it applies to other areas of social need.
It's also true. Here's another question, Joe. Thank you. It seems really important for the community to better appreciate the discretion and compassion practiced by law enforcement and your office, even if there are also some very difficult moments. How is your office able to communicate these types of valuable anecdotes to the community? It's a three-part question. Are there other forums like this one? What is appropriate and what isn't?
Yeah, thanks, Mr. Castleman, for that question. It's a great question. So for people that know me, I don't do a great job of sort of promoting the work of the office. I can't really speak for Chief Brackney and the police department, but I think they also, as public servants, are in it for the service and not sort of tooting their own horn. Having said that, I think it's important, and it's sort of built into your question, it's important to get the message out there of all the good things going on. So one of the things that when I took office that was very important to me is Eric Holder, who was President Obama's Attorney General. Before serving as President Obama's Attorney General, he was the United States Attorney for the District of Columbia, which was the District of Columbia's chief prosecutor. And they do federal, and there's a state component for crimes committed in DC. And we hear a lot about community policing, and there's a bunch of different definitions of that. But Eric Holder started community prosecution when he was the U.S. Attorney in DC. And Tim Hafey, who is local and used to be the U.S. Attorney for the Western District of Virginia, he's now counsel for the University of Virginia. Tim was an assistant U.S. Attorney in DC and worked for Eric Holder. And the model that Eric Holder set up in DC, the community prosecution model he set up was, I'm going to assign prosecutors, line prosecutors, to certain neighborhoods. And I want you to sort of be in those neighborhoods and attend neighborhood functions and, attend the weekend basketball tournaments and the cookouts and the neighborhood association meetings, and go to the mosques and the synagogues and the houses of worship. And he wanted them to be out and about, and he wanted them to be in certain neighborhoods. And the philosophy behind that was that when something happened or there was a problem, that the residents and the citizens of that neighborhood had a name and a face and a cell phone number or an email address to reach out and to talk to the prosecutor and have a relationship before something went wrong or went bad. And then if something did, they again had a personal relationship and knew people. So our attorneys are evaluated yearly during the process on, I want to know all the different community outreach events you attended and what you did and where did you go. And it's an expectation in this office that we do more than just go to court and prosecute cases. I want our lawyers, myself included, to be out in the community talking to people and engaging with people and interacting with people. And Charlottesville's a small community and it's a small town. And, I was brought to prosecution, as I told you, because of my interest in helping offenders. I've learned to appreciate the importance of advocating for victims in public safety. I grew into that and learned about it, but I was drawn to it to try and help my clients that were offenders. But they'll call me from the jail and be like, Joe, can you come prosecute me? I made a mistake. And I said, well, I can't talk to you. You've got an attorney. It's not appropriate, but it's good to talk to you, Billy. And I tell that little anecdote because there's a connection there with some of these folks and their families that I've had for almost 20 years. So again, I'm rambling. These are such great questions, but I think, Mr. Castleman, the answer is it's relationship after relationship after relationship. Tom Perriello said, go where you don't want to go and listen, and then go back, and then go back again, and then go back again. And so I think it's just being out there, being in the community when you don't need to be, and when there's not a reason, and when there's not a crisis, when there's not some, political benefit to be derived from it. And I found that to be the way to sort of build those bridges and relationships. And, I say now when people are like, well, what about this or that? I'm like, just ask around. Just ask around about my reputation, or ask around about the office's reputation, and you'll hear how I do and how we do. And it's not all good. It's not like we don't make mistakes or people don't, there's not people that disapprove of us, but that's a great question. And thanks for letting me share so much about it.
There is a common theme of relationships, it's the nearest core part of our mission is always finding ways to connect officers with citizens in the community. And I guess it's no different everywhere, isn't it? So there's some other questions. Wait a minute. Oh, wait a minute. This is about the relationship with the police department and what kind of oversight, or do you have oversight? How do you engage with them?
So, I think things have really changed for law enforcement officers over, I don't know if it's the last 12 to 24 months, but the increased scrutiny and pressure on the men and women in uniform as they discharge their duties. And I'm not saying it's inappropriate, but I think it's just become so much more heightened for them. And so we don't have oversight responsibilities for the police department. We work with them if there is criminal conduct on the part of an officer related to excessive use of force that rises to the level of criminal conduct. We would prosecute that or have it investigated, if it's potentially criminal and decline prosecution. That's a really tough, tense relationship to maintain when they know that, you are responsible for making decisions about what they do in the field, with being put in tough situations to make a snap judgment could potentially expose them to prosecution. Again, I sort of go back to relationships, and I had an officer I used to work with. He's a county officer, and I used to do a lot of narcotics work with him, and I just ran into him. And, I'm part of a group of 11 other elected prosecutors in Virginia. We recently formed VPPJ, Virginia Progressive Prosecutors for Justice. And there's 120 elected prosecutors in Virginia, and 12 of us formed an advocacy group, the first in the country. California has one, but we formed ours before them. And the 12 of us, and Jim Hingley's one of the 12 in Albemarle County, we are committed to criminal justice reform. and to bringing reform measures to our communities and statewide. And this county officer's like, Joe, I've known you forever and we're friends. And, a lot of police don't like what you're saying and what you're doing because it's seen as sort of a little softer on crime, a little permissive, a little anti-police. And we just had this great talk. And he was completely appropriate. He's like, I don't mean this personally, and I appreciate the fact that you can let me sort of share this with you. So it's not the easiest time right now when you have, more progressive prosecutors and interacting with police officers. There was a district attorney's election in Philadelphia yesterday, and Larry Krasner, who was elected 4 years ago. Larry Krasner was a civil rights lawyer that sued the police. That's what Larry Krasner did. And he was elected the district attorney of Philadelphia 4 years ago, which is one of the biggest jurisdictions in the country. And he came in as, a pretty bold reformer. And I'm not passing on positive or negative about Mr. Krasner, but he just defeated a prosecutor, a seasoned homicide prosecutor that he fired when he came into office, that was backed by the police unions and police officers in Philly. So there's a lot I think we're working through. And to me, what's most important is having officers believe in you and trust in you that you're going to sort of work on keeping the community safe and have their back where appropriate. But there's a national conversation going on about reform that, they're having to partake in. And I would say, in my experience, Chief Brackney's been sort of at the forefront of a lot of those different conversations and is very open to that and is very interested in reforming the way we do business. And it's controversial and not everyone likes it or supports it. So.
Do you have an opinion? Thank you. Do you have an opinion about what you consider to be a key critical reform in your opinion?
Wow, that's a great question. I think there's this narrative that some people won't even call it the criminal justice system now. They call it the criminal legal system. And words matter, and I understand that. I sometimes think some of that's semantics, but some people will call it the criminal legal system because they don't see that there's any justice in it. It's a criminal legal system. And I think there's this narrative that it's just not a fair system. And it's especially not fair to Black and brown folks. And it's especially not fair to folks that are indigent. And it's especially not fair to folks suffering with mental health conditions. And I think that's the narrative that's taken hold, again, not out of nowhere, not without reason. And I think in the presidential primary, back in I think it was the 90s with President Biden and President Clinton and the super predators and the tough on crime and the 3 strikes, there was a real law and order, lock people up reaction in the 90s. And it's a pendulum that kind of keeps swinging back and forth. And, to me now is the pendulum sort of cresting on some of this reform. And, there were 400 homicides in Philly last year. 400 homicides. Now, homicides and violent crime are up across the country because of COVID and other things, but is Larry Krasner and his policies, are they responsible for, I don't know the percentage of increase of homicides. Some people say yes, some say no. He says no. But what's the biggest area for reform? I think just working on every day, trying to have more anecdotes of fairness that can be shared. And I was treated okay. And, the system didn't punish me because of my race or gender or income level or mental health status. And we got a lot of work to do. And so I can't pick one specific thing. This past session of the General Assembly was historic. Virginia was the first Southern state to abolish the death penalty. And that's just a huge deal. I mean, certainly it was racially disparate and disproportional, but not only by defendant, but there was something called the Baldus study in a case in the U.S. Supreme Court, McCleskey v. Kemp. Race of victim mattered. Like, you were far more likely to get the death penalty if it was a white victim than if it was African American or Latino victim. So I think we're just having big conversations about some of this stuff, and I don't think there's a specific reform or a specific area. It's just systemically, we should be having the hard conversations. And like Anna said, what can we do to look at this stuff and be open to changing the way that we've always done things?
Well, and it seems like more systems need to change because it's the mental health resources that are so lacking that has caused, the situation in policing and mental health calls to be the way they are today, right? So here is another question. What are today's biggest challenges in bringing a case to trial? So examples are finding enough for the right evidence, witness or victim cooperation, or is there another one?
So it really depends on the case. I don't think I'm able to generalize and say, here's the biggest challenge. I will say this. Everyone's aware of the increased gun violence going on nationwide and certainly in our community. And we have 2 uncharged homicides in the city of Charlottesville. And I am positive there are people in our community that know who did it and that probably were present and witnessed it. And they just won't cooperate with law enforcement, and they don't want to come to court, and they don't want to be a snitch, and they just don't want to get involved. And so that's frustrating because someone lost their life, and they had parents and kids and siblings and friends and loved ones, and the barrier to, in certain instances, coming forward and providing information to law enforcement so that they can charge someone and we can prosecute them is frustrating. And I know law enforcement's extremely frustrated with it also, and there's nothing we can do about it. And that's a tough one that I really struggle with.
It sounds extremely impossible. Here's another question. What happens if a victim says they don't want to go forward with the trial, or if they want a harsher punishment? Who makes that decision? Do you make that?
So as attorneys, we have rules of professional conduct that govern ethically decisions we make and how we go about our job. And one of the rules is Rule 3.8, which deals specifically with prosecutors. And it lays out, commenting on things pre-trial to not affect the ability to seat a fair and impartial jury. But the rules have comments to them. And the comment to Rule 3.8 talks about a prosecutor being charged with being a minister of justice. Now, I have no idea what a minister of justice is. I don't know what the definition is. They certainly didn't teach us in law school what a minister of justice is. But as prosecutors, we don't represent the police. We don't represent victims. We don't necessarily have a client other than sort of society at large. The offender that's charged with a crime is just as much our responsibility as the victim or the case agent. So no, they don't have final say, and we have to be ministers of justice and filter through the wishes of case agents and victims with the defense arguments and the unique situations that the offender presents, and try and, what we do is a rough approximation of justice, as Dave Chapman used to say. But there are certain cases in domestic violence cases, they tend to be women that are the victims. They always come into court and recant and say, well, I ran into the door. I started it. I lied and he never hit me. That was an old bruise. And we sort of have a no drop policy on domestic violence cases, and we try and put them on through other ways. And so that that is an example of a case where we don't listen to the victim. We try and keep working with them. We try and keep communicating with them. We try and keep getting them to services, because our view is at some point in time, they may be ready to leave the cycle of violence and the abusive relationship. And when they do, we want to be there to help them. And if they come in and recant and say, I lied, we don't charge them with perjury. We don't charge them with obstruction of justice. We understand in those types of cases that that's the dynamic. And I'm prosecuting a manslaughter case right now. Someone ran over and killed a man, and he was here from England, and his widow just wants the young man to get 100 years in prison. And so she just wants, understandably so. And so she just wants one thing. And, he was a young guy that was out after curfew and was going too fast and made a mistake and panicked and left. And I'm not excusing it or justifying it, but those are two sort of competing interests that I have to try and strike a balance with. So it's sort of a rough approximation, but we try and factor everything in, but we don't always do what someone wants.
There are a lot of factors. Thank you. A question about the victims of crime. Does your service have, does your office have a section that supports victims, or are they referred beyond prosecuting their cases?
So every Commonwealth's attorney's office has a victim witness advocate and a victim witness program. So we have housed within our office across the hall, Pat O'Donnell is our victim witness coordinator, and we do have victim witness advocates that work with and reach out to victims and witnesses. So yes. And I saw there's another question in the chat.
You are right about that. Some people don't realize that nationally, at least, far more cases are resolved by plea bargain rather than trial. Can you say something about numbers in Charlottesville?
Great question. And I think, I don't know if the question was intended as a criticism of the system, but a lot of times you see that it is a criticism, because people have all sorts of constitutional protections and safeguards. And really, when you're charged with a crime, you don't have to put on any evidence. You're presumed innocent. It's like, well, go ahead and let's have a trial and let me see in a public way and test the evidence against me. So one of the criticisms is, well, if everyone pleads out, how is there sort of any testing of the allegation made against you? So a couple, I don't know the numbers in Charlottesville. There certainly are very few.
You just froze, Joe. We have lost Joe for the moment. There you are.
I lost myself for a minute. Am I back?
Yes, you are back. There and back.
Okay. One thing I would say related to that question is, some prosecutors say, well, here's the offer, take it or leave it. And defendants don't get to see the evidence against them. Locally in Charlottesville, we have always had this. We have open file. So before a defendant or an offender has to make any decision, they get to see everything we have. It's open file. They just ask for it. We send it all to them. So they get to see all of the evidence against them when they make their decision, if they want to accept a plea agreement or go to trial. There also was a recent reform that I'm supportive of that just happened this past session of the General Assembly. If you sell a 25 to 40 years in prison. So if you go to a jury trial, a jury has to start at 5 years in prison. They can't give you anything less than that. So they just reformed Virginia, and we're one of the few states that had jury sentencing. So they just changed the law. That you can have a jury trial for guilt. So some people say that's going to lead to more trials. I'm not particularly concerned about that in Charlottesville, but we turn over all of our evidence. We try and make a fair offer to resolve the case. If we can't come to agreement, we're trial lawyers and we're decision makers, and you can find is reasonable. I don't know if that answered the question or not.
I think we heard as best we could. I think that you're still cutting in and out a little bit. There was another question about alternatives to incarceration. So you talked about your anecdote about reducing the charge, but what are the other opportunities for offenders who are fortunate enough not to have to go to prison?
So we have, philosophy for breakfast, or I forgot the quote, but we have sort of generally, if someone's charged with a felony and it's non-violent, culture eats strategy for breakfast, that's what it is. If someone's charged with the first felony, non-violent, we try and reduce that to a misdemeanor right out of the gate. And again, we always check with victims and case agents on these agreements. We have the second oldest drug court in the Commonwealth of Virginia. And so that's a treatment model. It's for high risk, high needs people. If someone's a recreational user of cocaine on the weekend and they get caught with a little bit, they have a different diversionary program called pre-conviction probation, where they do a little community service and, test clean for a little while, and they don't need the intensive services. So pre-conviction probation is a statutory scheme for folks like that. But the drug treatment court is very intensive, very oriented. And that's someone's got the area's first ever therapeutic docket for misdemeanors. So that's something that we have as an option for misdemeanors. I think we'd like to see that expanded, but it's still growing. We want to do it responsibly. There's the Bridge Ministry Program in Buckingham, Virginia, that Jay James and William Washington run, and see if the different services that are available. I know Anna and Mental Health America have worked with a lot of people and just said, well, let us have them for 6 or 12 months and then come back and report to the court. So some of it's a little bit more informal with some of the providers in the community.
Great.
I'd like to, Gail, I know we're almost out of time. I don't see any other questions. Can I close with one other thing?
Yes, by all means, please do.
So this goes to Mr. Castleman's question about how do you sort of get the word out, and you'll all be ambassadors to pass on. Jail population, it says I'm unstable again. I don't know what's going on with my internet. I'm sorry. Our jail population is at the lowest level it's been in over 20 years. And I think no one being in jail by itself isn't a good thing. But we have really gotten people need to be there. And one of the things we've done when COVID hit in March of last year is there's a home electronic incarceration program that is paid for by the jail. So it's at no cost. And people have a GPS ankle monitor put on them. And in the custody of the jail, but they're at home on arrest or at work or in treatment, and they have drug screens. And so we've really utilized that, and we did it to sort of keep the number of people in the facility at a minimum to try and reduce the spread of COVID. I think we're going to do a lot of stuff program. So that's kind of an exciting thing that's been going on, that we really are making great use of that. And that's judges and defense attorneys and probation officers. It's not just prosecutors, but that's helped us keep our numbers low. And I think we're utilize that. Not everyone monitor, and they're still committed new offenses, and they were nonviolent. So I just wanted to close with, that's a great program, and Martin Coomer at the jail has been a wonderful stakeholder in implementing that program.
That is a great program. That's very, very good to hear. And Joe, I and we cannot thank you enough for taking the time to share all this information. It's so much, is a lot that we just don't know, or we lay people, I should say. So we will end, and I wish you all a terrific afternoon. Next month, the Lunch and Learn will be on Wednesday, June 16th, and the topic is the crisis negotiations team at CPD. So in the meantime, everyone be safe and well, and we'll see you next time. Thank you so much for coming. Thank you.